Internees Chapter 5 Religious, Intellectual and Physical Activities Art. Point 93. Internees shall enjoy complete latitude in the exercise of their religious duties, including attendance at the services of their faith, on condition that they comply with the disciplinary routine prescribed by the detaining authorities. Ministers of religion who are interned shall be allowed to minister freely to the members of their community. For this purpose, the detaining power shall ensure their equitable allocation amongst the various places of internment in which there are internees speaking the same language and belonging to the same religion. Should such ministers be too few in number, the detaining power shall provide them with the necessary facilities, including means of transport, for moving from one place to another, and they shall be authorized to visit any internees who are in hospital. Ministers of religion shall be at liberty to correspond on matters concerning their ministry with the religious authorities in the country of detention and, as far as possible, with the international religious organizations of their faith. Such correspondence shall not be considered as forming a part of the quota mentioned in Article 107. It shall, however, be subject to the provisions of Article 112. When internees do not have at their disposal the assistance of ministers of their faith, or should these latter be too few in number, the local religious authorities of the same faith may appoint, in agreement with the detaining power, a minister of the internee's faith, or, if such a course is feasible from a denominational point of view, a minister of similar religion or a qualified layman. The latter shall enjoy the facilities granted to the ministry he has assumed. Persons so appointed shall comply with all regulations laid down by the detaining power in the interests of discipline and security. Art. 94. The detaining power shall encourage intellectual, educational, and recreational pursuits, sports, and games amongst internees, whilst leaving them free to take part in them or not. It shall take all practicable measures to ensure the exercise thereof, in particular by providing suitable premises. All possible facilities shall be granted to internees to continue their studies or to take up new subjects. The education of children and young people shall be ensured. They shall be allowed to attend schools either within the place of internment or outside. Internees shall be given opportunities for physical exercise, sports, and outdoor games. For this purpose, sufficient open spaces shall be set aside in all places of internment. Special playgrounds shall be reserved for children and young people. Art. 95. The detaining power shall not employ internees as workers, unless they so desire. Employment which, if undertaken under compulsion by a protected person not in internment, would involve a breach of Articles 40 or 51 of the present Convention, and employment on work which is of a degrading or humiliating character are in any case prohibited. After a working period of 6 weeks, internees shall be free to give up work at any moment, subject to 8 days' notice. These provisions constitute no obstacle to the right of the detaining power to employ interned doctors, dentists, and other medical personnel in their professional capacity on behalf of their fellow internees, or to employ internees for administrative and maintenance work in places of internment and to detail such persons for work in the kitchens or for other domestic tasks, or to require such persons to undertake duties connected with the protection of internees against aerial bombardment or other war risks. No. Internee may, however, be required to perform tasks for which he is, in the opinion of a medical officer, physically unsuited. The detaining power shall take entire responsibility for all working conditions, for medical attention, for the payment of wages, and for ensuring that all employed internees receive compensation for occupational accidents and diseases. The standards prescribed for the said working conditions and for compensation shall be in accordance with the national laws and regulations, and with the existing practice. They shall in no case be inferior to those obtaining for work of the same nature in the same district. Wages for work done shall be determined on an equitable basis by special agreements between the internees, the detaining power, and, if the case arises, employers other than the detaining power, due regard being paid to the obligation of the detaining power to provide for free maintenance of internees and for the medical attention which their state of health may require. Internees permanently detailed for categories of work mentioned in the third paragraph of this article shall be paid fair wages by the detaining power. The working conditions and the scale of compensation for occupational accidents and diseases to internees, thus detailed, shall not be inferior to those applicable to work of the same nature in the same district. Art. 96. All labor detachments shall remain part of and dependent upon a place of internment. The competent authorities of the detaining power and the commandant of a place of internment shall be responsible for the observance in a labor detachment of the provisions of the present convention. The commandant shall keep an up-to-date list of the labor detachments subordinate to him and shall communicate it to the delegates of the protecting power, of the International Committee of the Red Cross, and of other humanitarian organizations who may visit the places of internment. Chapter 6: Personal Property and Financial Resources. Art. 97. Internees shall be permitted to retain articles of personal use. Monies, checks, bonds, etc., and valuables in their possession may not be taken from them except in accordance with established procedure. Detailed receipts shall be given therefor. The amounts shall be paid into the account of every internee as provided for in Article 98. Such amounts may not be converted into any other currency unless legislation in force in the territory in which the owner is in turn so requires or the internee gives his consent. Articles which have above all a personal or sentimental value may not be taken away. A woman internee shall not be searched except by a woman. On release or repatriation, internees shall be given all articles, monies, or other valuables taken from them during internment and shall receive in currency the balance of any credit to their accounts kept in accordance with Article 98, with the exception of any articles or amounts withheld by the detaining power by virtue of its legislation in force. If the property of an internee is so withheld, the owner shall receive a detailed receipt. Family or identity documents in the possession of internees may not be taken away without a receipt being given. At no time shall internees be left without identity documents. If they have none, they shall be issued with special documents drawn up by the detaining authorities, which will serve as their identity papers until the end of their internment. Internees may keep on their persons a certain amount of money, in cash or in the shape of purchase coupons, to enable them to make purchases. Art. 98. All internees shall receive regular allowances, sufficient to enable them to purchase goods and articles, such as tobacco, toilet requisites, etc. Such allowances may take the form of credits or purchase coupons. Furthermore, internees may receive allowances from the power to which they owe allegiance, the protecting powers, the organizations which may assist them, or their families, as well as the income on their property in accordance with the law of the detaining power. The amount of allowances granted by the power to which they owe allegiance shall be the same for each category of internees, infirm, sick, pregnant women, etc., but may not be allocated by that power or distributed by the detaining power on the basis of discriminations between internees which are prohibited by Article 27 of the present convention. The detaining power shall open a regular account for every internee, to which shall be credited the allowances named in the present article, the wages earned and the remittances received, together with such sums taken from him as may be available under the legislation in force in the territory in which he is interned. Internees shall be granted all facilities consistent with the legislation in force in such territory to make remittances to their families and to other dependents. They may draw from their accounts the amounts necessary for their personal expenses, within the limits fixed by the detaining power. They shall at all times be afforded reasonable facilities for consulting and obtaining copies of their accounts. A statement of accounts shall be furnished to the protecting power on request, and shall accompany the internee in case of transfer. Chapter 7 Administration and Discipline Art. 99. Every place of internment shall be put under the authority of a responsible officer, chosen from the regular military forces or the regular civil. Administration of the detaining power. The officer in charge of the place of internment must have in his possession a copy of the present convention in the official language, or one of the official languages, of his country, and shall be responsible for its application. The staff in control of internees shall be instructed in the provisions of the present convention and of the administrative measures adopted to ensure its application. The text of the present convention and the texts of special agreements concluded under the said convention shall be posted inside the place of internment, in a language which the internees understand, or shall be in the possession of the internee committee. Regulations, orders, notices, and publications of every kind shall be communicated to the internees and posted inside the places of internment, in a language which they understand. Every order and command addressed to internees individually must likewise be given in a language which they understand. Art. 100. The disciplinary regime in places of internment shall be consistent with humanitarian principles, and shall in no circumstances include regulations imposing on internees any physical exertion dangerous to their health, or involving physical or moral victimization. Identification by tattooing or imprinting signs or markings on the body is prohibited. In particular, prolonged standing and roll calls, punishment drill, military drill and maneuvers, or the reduction of food rations are prohibited. Art. 101. Internees shall have the right to present to the authorities in whose power they are any petition with regard to the conditions of internment to which they are subjected. They shall also have the right to apply without restriction through the internee committee, or, if they consider it necessary, direct to the representatives of the protecting power, in order to indicate to them any points on which they may have complaints to make with regard to the conditions of internment. Such petitions and complaints shall be transmitted forthwith and without alteration, and even if the latter are recognized to be unfounded, they may not occasion any punishment. Periodic reports on the situation in places of internment and as to the needs of the internees may be sent by the internee committees to the representatives of the protecting powers. Art. 102. In every place of internment, the internees shall freely elect by secret ballot every 6 months the members of a committee empowered to represent them before the detaining and the protecting powers, the International Committee of the Red Cross, and any other organization which may assist them. The members of the committee shall be eligible for re-election. Internees so elected shall enter upon their duties after their election has been approved by the detaining authorities. The reasons for any refusals or dismissals shall be communicated to the protecting powers concerned. Art. 103. The internee committees shall further the physical, spiritual, and intellectual well-being of the internees. In case the internees decide, in particular, to organize a system of mutual assistance amongst themselves, this organization would be within the competence of the committees in addition to the special duties entrusted to them under other provisions of the present convention. Art. 104. Members of internee committees shall not be required to perform any other work, if the accomplishment of their duties is rendered more difficult thereby. Members of internee committees may appoint from amongst the internees such assistants as they may require. All material facilities shall be granted to them, particularly a certain freedom of movement necessary for the accomplishment of their duties, visits to labor detachments, receipt of supplies, etc. All facilities shall likewise be accorded to members of internee committees for communication by post and telegraph with the detaining authorities, the protecting powers, the International Committee of the Red Cross and their delegates, and with the organizations which give assistance to internees. Committee members in labor detachments shall enjoy similar facilities for communication with their internee committee in the principal place of internment. Such communications shall not be limited, nor considered as forming a part of the quota mentioned in Article 107. Members of internee committees who are transferred shall be allowed a reasonable time to acquaint their successors with current affairs.